So please, Jørn.
Yes, thank you very much, Jukka, for this kind introduction and for the invitation to give a speech at your seminar. As I told Jukka, I had to improvise a little bit because I am sitting very intensely this week together with two friends, one from Bergen and one from Belgium, to write an article about women's legal rights in the Middle Ages. So it's a little bit different from what I think you have an interest in. But it is a great pleasure to talk about how to apply legal history in a company law thesis, and then more, maybe specifically if you're writing also about sustainability. So I'm going to link all my examples in this speech to company law or to sustainability and not to legal history in general, hopefully to make it more relevant for the theses that you are writing. I wanted to start very basic, because why apply legal history? Well, it is because it is beneficial, but beneficial for what? So let's start with what is the purpose of a PhD thesis? And I've just simply explained it as establishing certainty where there have been no knowledge or there's been limited or uncertain knowledge so far. So we're talking about seeing things in a new way. That means that you either have to use new sources or you have to apply known sources in a new way. You need a new perspective on existing sources that have been applied by others for other purposes. And I like to explain this relationship between the sources that we have and what we are going to produce, this new knowledge, this new certainty, by using two terms developed by the German social historian Reinhard Koselleck. So Reinhard Koselleck operated with the terms room of experience and horizon of expectations. And in one way, this is not rocket science, because he's trying to explain something that all scientists has to deal with and have experience with. But by developing these two terms, I think he managed to frame this relationship between sources and new knowledge very well. So think about your sources as different kinds of experience. It's something that is known and can be studied. It can be literature, it can be court practice, it can be legislation. There's a lot of experiences of different kind. And think of these sources as stored away in a storage. They're all in different shelves. And what we do as when we write a PhD thesis or any kind of work of science is that we pick different experiences and we combine them. So they're all there in the storage room, but we try to combine them in a new way. And that is what creates the horizon of expectations. So what we can imagine is totally dependent on the experiences we have. But we can imagine different things because of the multitude of experiences. We can pick and choose and combine them in a new way. That's what we do in a PhD thesis. As I said, sometimes we can use a new source. There might be a new piece of legislation still not in action that we study to write a PhD thesis. We're the first to talk about this piece of legislation. There's not going to be a lot of direct relevant experience to that. That's most of the time not the case. So I think most of you, when you work with your thesis, thinking about this room of experience and how it's linked to the horizon of expectations might be useful. But the problem is, when we get into this storage room, this room of experience, how do we choose between the different sources and how do we combine them? Well, what we need then is a perspective. And what is this perspective? I describe it as an instrument to get on a distance, to get closer to a subject. Now, that definitely sounds like a contradiction in terms, because you cannot get on a distance and at the same time get closer. That's impossible logically. But it still makes sense, because when I get into this room of experience and I have to choose my sources and I find a way to combine them, I cannot do that based on my personal experiences from previously. It has to be an objective selection of sources, an objective way of combining them. By objective, I mean it will make logic sense to others, the choice of sources and how you combine them. So how do I know that I choose these sources objectively and not based on my preferences, my policy preferences, for instance, etc., etc. So this is the perspective is what keeps you from approaching the scientific material in a subjective way, making it non-science. And that is the purpose of a perspective. And there are a multitude of different ways of getting such a perspective. There's a lot of sciences that are in, we used to say they're in the periphery of law. I don't like thinking about my own subject, legal history, as in the periphery of law, because I think I'm in the midst of absolutely every topic, because every topic in law has a history. And I think Jukka would say the same for legal economics. We're not in the periphery, but that's how it was used to be perceived, at least back in the 1980s and 90s. But there is at least a lot of sciences which combine with law and literature, legal philosophy, law and economics, legal history. All these kind of sciences can help us to create this kind of a perspective, this kind of a distance that makes us able to choose the sources and combine them in an objective way. So statistics, this is the field of Jukka, of course, but that is maybe the most obvious way of doing it. So statistics on what kind of companies do actually dominate in society. When we're writing company law, what kind of companies are we writing for? What are out there in the real world? Are there small, medium, or large companies? Are there family-owned companies? Or are there big global companies? I mean, what is out there? That's one way of getting a perspective to company law and what you're going to work with. What kind of sources and to what aim are you working with these sources? And statistics on what are the importance of different companies. What is the output, or how many people do different kind of companies employ, for instance? That's the kind of statistics that I would like to know when I work with company law. Now, I don't work with law and economics, and I do produce statistics actually quite a lot. Not because I think statistics gives you an answer, but it tells you a lot about what questions to ask. And that's how I use statistics. But my field, and what I'm going to talk about today, is how to use legal history. Now, the problem when we talk about company law, especially if we combine company law with sustainability, is that people have a tendency to think that legal history doesn't matter. I mean, how much sustainability was a topic in Roman law? The answer is quite a lot, actually, surprisingly a lot, but I'm not going to dwell a lot with that. But we have to keep in mind that legal history is not only ancient legal history. We do find sustainability as a topic also in ancient legal history. And for instance, the regulation of rivers, which I think is both the beginning of law, but also a beginning of thinking of sustainability. So the huge complex civilization, which needed lots of legislation to regulate complex interactions, economic and social complex interactions, we find along the big rivers in the world. So like the Nile or different rivers in the world. And what is the problem with these rivers is that they can, you can use the water to water your crops, but these rivers runs for miles and miles and miles and miles. And if you use too much water at the top of the river, there's going to be nothing left for those at the bottom of the river. And hence the first legislation produced is all about who can apply how much water so everybody get their share. It's a kind of a sustainability idea behind it all. So you will find in ancient legislation also something of interest when you work on company law and even on sustainability. But the most important thing is legal history is more than ancient legal history. It is also recent legal history. I'm going to show you some statistics because, as I said, I love statistics and I use them a lot in my research. But I'm going to show you some statistics showing the increase in the awareness of sustainability the last 15 years. But 15 years is also a legal historical period that you can approach by using a legal historical method. It is, of course, because anything that is in the past, anything that was yesterday or 1 hour ago, is legal history. And when things are changing very rapidly, which they are today, we're in a period of rapid legal change, which we rarely see in legal history. It only happens every now and then. So we haven't experienced these rapid changes for a couple of 100 years, actually. Then 15 years of legal history is actually a legal historical period worth examining. So for you writing on company law, maybe recent legal history is more relevant than ancient legal history, but legal history is still relevant for you. So how can you use legal history in your thesis? Well, the first thing is simply to establish what I call an open mind. Now, I've been talking about this room of experience. Now, all of us has a room of experience, where there is a mix of experiences from our personal life and our professional life. And these experiences are going to be different. So the experiences of somebody who studied law in the 70s are going to be different from somebody who studied law in this millennia, because law was so different. The legal sources you applied in the 70s were different from the ones you apply in this millennia. For instance, EU law of no relevance in the 70s, of great relevance now. So somebody who have studied law in this millennia in their room of experience will have many more experiences related to EU law, the European human rights, than maybe somebody who studied law in the 1970s. So what you want to do is to reach out to all these readers with different perceptions of what you're going to write about. So you write about company law. Well, company law has changed a lot, so there's different perceptions, and you want them to read your thesis with an open mind and to free them from their room of experience. So then you can use legal history and just have it in the introduction of your thesis or in an introductory chapter where you, for instance, talk about the regulations of rivers, because maybe the reader, maybe you're afraid the reader is going to think that sustainability, this is this kind of modern fashion thing that soon's going to pass. Well, why don't you then talk about regulation of rivers in ancient history, saying sustainability is something that is a huge topic today, and it's becoming a huge topic of law, but we cannot imagine law without taking sustainability into consideration, for instance. And then you talk about regulation of rivers, etc., and that's to open the mind of the reader, thinking no longer this is just a fashion that is going to pass, but yes, this is an imminent part of law, and I'm now going to be introduced to another stage of this imminence in law. So that's the way that everybody can use legal history in their thesis, just to open the mind of the reader. When you do that, legal history is a perspective that you only find usually in the introductory chapter or as a separate introduction chapter. This perspective will then not reappear during the thesis because it has already fulfilled its purpose as soon as the reader has an open mind. Now, what becomes more difficult and more challenging and demands more knowledge in legal historical method is when you try to create a longue durée, so the long lines in history, and placing your topic in this long line. For instance, and I've given you an example here, you want to convince the reader that when you're writing about company law, it is because company law is in huge change. Now, the reader might immediately argue that, well, every generation thinks that law in their time is changing more than ever before. And that has been claimed in every generation as logically impossible. Hence, your claim that company law is changing more or going through large changes today is just a subjective claim based on your personal experience. So if you have the idea that company law is in a period of change, I think you can also observe, as I've stated it on my slide, that companies are at any time in history dependent on communication. So a company is something done between several persons or entities, and they have to communicate. They have to communicate internally. So different parts of the company do different things. They have to communicate to do the things they all need to do. You have to communicate to the company partners. So there's several people are putting capital, taking risk together. There has to be communication between them. And there's also an external communication because the company is serving somebody or something out there. There has to be a communication to the business partners. What we see in history, and this is the longue durée, that is that when communication, since companies are totally dependent on communication, when there's a huge change in communication, company law changes. So if I were to pinpoint when do company law change in Norwegian history, for instance, I would first state the 13th century. That's a period of great change in law because you start using writing in Norwegian law. The art of communication within law and in business changes. Writing makes new things possible, other things impossible, and you hence have to change company law. There's huge changes in Norwegian company law with the Code of 1274. Next time there's changes taking place is in the 18th and then later in the 19th century. And that's because you start using printing now. It seems a little bit late to start using printing in the 18th century, but actually the first piece of legislation ever printed in Norway was in 1604. And we're a bit late in the European context, but there's not a lot of printing in general of legal text, even in the 16th century, actually, all over Europe, including Germany, for instance. Most printing becomes the dominant way of communicating within law in the 17th century, and we see the consequences in the 18th century when company law starts to change, at least in the Norwegian context. But the changes are complete during the 19th century. And what is happening today? Well, we have the digitalization of law. It's totally changing company law and all law simply because the mode of communicating changes so dramatically. Hence, there are good reasons for arguing that company law is going through a long change, through large changes today, because when we look at the longue durée, the long lines in history, this happens when communication technology changes, and it is changing today. Hence, you're convinced your reader. That's one way of using legal history in your thesis. Another way, which is even more demanding, is to use legal history to identify general values or principles to be observed. Now, first of all, I should have said, when you create a longue durée, usually you do that in the introduction and then you return to it at the end of your thesis. So different from just opening up the reader's mind, when you don't return to the use of legal history in the introductory chapter, you do return to such a longue durée in your conclusion, repeating why company law are going through major changes. Now, legal history to identify general values or principles are difficult because, but is a more productive, I would say, maybe one of the most productive ways of using legal history in a thesis. On a surface level, let me show you this first. So some of you read and speak Norwegian, and then you can make sense of this this cartoon, but I'll try to explain to you what it actually means. This is my very own version of the philosophy of Carlo Turri. And I don't know if Carlo would approve. We do talk every now and then, and we have a good laugh. And sometimes he laughs of my use of his legal theory, I must admit. But I think it is very useful to boil it all down to the legal sea. So if you imagine this is the sea, it's divided in 3 different levels. So this is the top level where you find the small fishes, and that's where you find the legal rules. So they're continuously changing. Also in company law, you get changes every year in legislation or in legal practice, etc., etc. On a middle level, you have the principles of any legal field. They change a lot more slowly. And at the bottom level, we found the foundations of a legal field. They hardly change ever. So if we look at Norwegian company law, I would again say these changes in the 13th century, in the 18th century, and today. This is the only times the bottom of the legal sea has changed what company law concerns. Principles, they change maybe every 50, 100 years, while the legal rules, they change from year to year. So keep this legal sea in your mind when we return. So when you write your thesis, you are going to write also about legal rules and recommend rules or explain rules or combine rules or whatever you do. But keep in mind that below these rules, there's always principles and values and the foundations of company law. And sometimes identifying those principles help you to understand the rules and the interaction between the rules on a surface level. And you can use legal history to identify these general values or principles. Sometimes they're stated in legislation, for instance. Other times, you have to go through history and say, well, this reappears every now and then. I made it very simple for myself. This is not advanced. But I just put on 2 observations and a conclusion. You know, in your thesis, you can observe through history that companies are established to raise capital and to divide risk. It's some of the most fundamental things about companies. But also that with capital and risk, there comes power to make decisions. Now, if you identify, if that's possible, that this is the case all through history, then you say that in my thesis, I have to take this into consideration. So when I establish and recommend rules for the future in company law, I will always take this into consideration to make sure that the possibility to raise capital, the necessity of dividing risk, and the outcome, that is power to make decisions, are always taken into consideration. Now, I made this very simple. This is not really a good example, but you know, there's going to be so much difference between the topics of your thesis. So I made something very basic, but the idea can be generated and developed and used in most theses, I think. And this is a perspective not to only be addressed in the introductory chapter, not only to be addressed in the introductory chapter and the conclusion, but throughout the thesis. It's hence more demanding to produce because you have to be more precise, apply more of a correct legal historical method, but then you got a super tool to convince the reader that this is the best solution because this solution promotes these general values or principles within company law that we have identified in history. So this is more demanding, but it is more productive than the 2 previous examples of how you can use legal history. Another way of using legal history is to establish an should have been act direction of change. Now, this is maybe most relevant for those of you who want to work with immediate legal history. And there's good reasons, as I've already stated, to work with immediate legal history when you work on company law and you work on company law and sustainability, because the changes has been immense the last 50 years. And actually, when it comes to sustainability, the last 20 years. And I'll show you soon with some statistics. So one way of establishing, for instance, a a direction of change is by, for instance, studying the content of the term sustainability. Now, this is actually a separate line of scientific research. It's called in German, and this is a German specialty. It's called Begriffsgeschichte. You don't have a very good term in English. You could call it, the history of terminology or something like that. But Begriffsgeschichte is in German really a field of study. And I've already mentioned Reinhard Koselleck, who invented the room of experience and the horizon of expectations. He is also the editor of this impressive scholarly work on the 100 most important legal terms in history. So rule of law in German, Rechtsstaat, or Staat, Richter, Gesetz. All of these terms do have their own articles. Some of them are, like Rechtsstaat, rule of law. The articles are 100 pages long, only about what is the content of this term from antiquity to today. I don't ask you to do that because it's, as I said, a separate field of legal history, of study. But what you can do, and for instance, now I have a student who is writing his thesis about rule of law in the practice of the European Human Rights Court and the EU Court. It goes back not further than 2011, when he says rule of law was only an idea, and it was not made or deduced into concrete legal rules. But with the challenges from first Hungary and then Poland, and the problems with rule of law in those countries, rule of law had to be, by the courts, developed from a general idea to specific legal rules. And what about sustainability? I bet it has gone through a similar development. Well, I don't only bet, I've actually seen it. So, and that is one thing that you could do. You could see how sustainability is getting more and more of a concrete content, being turned from a general idea to legal rules, to justify saying that my thesis and what I advocate is just the next generation of sustainability rules. That is, again, something more for those who work on immediate legal history, but it is also a very, very productive and fruitful way of using legal history in a thesis. Again, like identifying values and principles, we're talking about a way of using legal history that can be addressed throughout the thesis. Now, by all means, I have to also add something. Since I'm a legal historian, I cannot give this speech without saying that, keep in mind, legal history can also be the purpose of a thesis. So legal historians, they write a thesis, not with legal history in an introductory chapter or something like that, but on legal history alone. And the history of company law, for instance, is as old as the history of law itself. There's a lot of legal historical topics to choose. You probably, if you write about company law today, you probably know something about company law in ancient Rome. You probably know something about how it was developed in the 13th and, well, especially the 12th and 13th and 14th, maybe more 14th centuries, with the growth of the Italian city-states, how it was again immensely developed during the 18th and 19th century, and the changes that has taken place after, for instance, the 1970s, when the reconstruction of this after the Second World War was over, but also how it has radically changed since the 1990s with the fall of the Berlin Wall and the emergence of the kind of global trade we take for granted today. And factors that played an immense role is, of course, peace, the fall of the Berlin Wall and the end of the Cold War, computers and internet, that's the change in communication I've been talking about, but also other factors like the role of real estate in raising capital in liberal societies. So keep in mind, if you like, if I might, maybe I'll be able to convince you to switch from Jukka's topic, company law, to my topic, legal history. But you could combine them and write legal history or company law's legal history. But just, company law is no exception. Most topics can also be the subject of legal historical research alone. I've been talking about sustainability a bit and said that, if you write on sustainability or company law and sustainability, it is maybe immediate legal history that is most relevant for you. Doesn't have to be that way, but it might be. And that is because you have quite a change in the role of sustainability in science and in society. And these are just some simple statistics. So I went through all the Norwegian journals, so every journal published in Norway. And I just made these statistics from year 2000 till the present. And what I searched for is how often is sustainability referred to? And you see this increase just from 2020 to 2021. But also, first it starts booming 2018, 2019, and it's tripled in 1 year. And then you go from 707 references to sustainability to 3,414. It's just this enormous growth in references to sustainability. We're not talking about legal journals, we're talking about all journals. But if you look at newspapers, you see the same thing, just that it started even before with this heavy growth of references to sustainability. And it's kind of evened out. So it started in newspapers, went on to journals, and it still hasn't really caught up in books, but you're starting also in books to see an increase in references to sustainability. And I think it is this kind of very simple statistics is very easy to make. And they don't give us answers, they just tell us something is going on. And you always have to read behind the statistics. Because if you look at references on sustainability, there's also quite some references to sustainability. For instance, in the 60s, there's a big boom in references to sustainability in the 1960s, but they're all to economic sustainability, not to environmental sustainability. So you have to be able to filter and so forth to make them more nuanced, but I've done that, and this is all references to environmental sustainability. But it is only to convince you there's something happening. And this, when it comes to journals, it tells you how much that can happen in just 1 year when the awareness of sustainability is increasing as it is in our society. Now, hopefully I've shown you different perspectives achieved by using legal history in a thesis. They're all very different. They all demand a different degree of legal method and insight in legal history, etc., etc. But as you can see, legal history can be used by all, from opening up the mind to writing a complete thesis on legal history. And it is all to achieve a perspective, so that objective distance you need when you get into the room of experience to sort out what sources to use and how to combine them. But I've been then talking about indirectly sources all along, but I want to make some special remarks on the sources you use when you use legal history in a PhD thesis. The first thing is that you use legal sources. So your lawyers, I think, at least presumably, you use legal sources, and you do that in your thesis, whether you apply a legal historical perspective or not, and you will use the whole range of legal sources, legislation, preparatory work, which is such an important legal source in the Nordic countries, legal practice, legal literature, etc., etc. It's all a question of what is accessible, what is searchable for your purpose. What you have to keep in mind is, because some feel that, doing legal history, I'm not an historian, what do I know about historical legal sources, etc., etc. Well, legal historians work a lot, mainly almost, with legal sources, because they are also historical sources. Legal sources always tell us about what was law in the past, as well as they can tell us what is the law in the present. So you always have past legal sources, legislation that used to be like the Code of 1274 that tells us about the changes in company law in Norway in the 13th century. But present legal sources are also legal historical sources. There's always an historical element with them. So legislation are produced at a certain point in time. The preparatory work will tell you about the whole context of this legislation. What were people thinking? How were they arguing? Why was this seen as important? What options were there? What choices were made? The preparatory work for a piece of legislation and the legislation in itself will give you a lot of legal historical information. And that's the sources legal historians primarily work with. And again, that means that writing immediate legal history is not that difficult because you only use the sources differently. You try to separate the historical aspect from the present law aspect, but it is very much the same sources you apply. Legal historians, of course, also use historical sources. We are historians as well as lawyers. And when you write your thesis, I would also want to use historical sources. But what you have to keep in mind that you use historical sources to contextualize. So your main sources are still going to be the legal sources that you as lawyers are very competent to work with. And the historical sources are used for contextualization when you write legal history. And that skill is very obtainable. And then we return to my very simplistic version of Carlo Dori's philosophy and the legal C, because we can also use this to explain something different. Now at the top level, you have what I would call the pure legal sources, so legislation and the rules that you find in it. The deeper you get in the legal C, down to principles and down to foundations, you need a context, a social context, political context, economic context, philosophical context, historical context. So the deeper you get into that legal C to study all the way down to the foundations, so for instance, company law, the more you need to contextualize and use legal historical source. But whatever you do, keep in mind, your legal sources will always be your primary sources. Using the term primary sources, I also have to speak about the two major categories of legal historical sources. This could be made much, much more complicated. I could turn it into a separate speech and a very long speech. But I'm going to do this very simple because you're not supposed to become legal historians. You're company law lawyers, but you use, hopefully, legal history as a perspective. And what you then have to keep in mind that there are primary and secondary legal historical sources. But when we speak of primary and secondary legal historical sources, it doesn't mean that some sources are primary and secondary in quality. They have the same, they are on the same level of quality, but they have different kinds of quality. The primary sources are the sources from the time of the event or action, and it has the quality of the immediate. So a preparatory work, for instance, will give you an insight, or the discussions in Parliament when voting on a piece of legislation gives you an insight in what were they thinking as they made this legislation. That's a primary source, legal historical source. Secondary sources has a very different quality. It's not the quality of the immediate, because they are not immediate. It has the quality of synthesis and analysis, So those are sources made later on where you add together several primary sources and you put them together, you make a synthesis and you analyze them and you come to a conclusion on what happened back then. That's a primary source. It has a great degree of quality because the weakness of the immediate sources, the strength is, of course, you get to know what were people thinking, but people are so involved in the business that they're not on a distance So hence, they do not always produce the deepest of thoughts. The secondary sources have deeper thoughts often because they have the advantage of being on a distance and analyzing something that happened back then. So it's very different kind of sources. And if you write legal history and you use it in your thesis and you use it just to establish an open mind, then you can use both primary and secondary sources, but usually you'll find with the secondary sources, you can rely on the research done by others. Sometimes it is great fun to use primary sources. So as I told you in the introduction, I'm sitting here in Bergen writing an article with a colleague from Bergen and one from Belgium, and we're writing about women's rights in the Middle Ages. And it is a topic which has been totally overlooked, because in the legislation and in the legal practice in the Middle Ages, they talk always about mother. And mother is, as you can probably hear, it's the Old Norse word for man. But the Bible in Old Norse starts with that God created two men, Adam and Eve. And it sounds so weird to us, but it's because mother both means man and mankind. So what the Bible in Old Norse says actually is that God created two of the mankind, Adam and Eve. Now, using what I'm doing now is using a primary source, the Old Norse Bible, to open your minds. When we start the article with this quote, and of course then the reader thinks, wow, we've missed out. This is the key. This article has something new because they've understood that mother is not simply man, but mankind. And I'm convinced by this single quote alone. Wouldn't make sense, would it? If the Bible were in Old Norse were an advocate for homosexuality. So it's an use of a primary source to open the reader's mind, but usually you can settle with using secondary sources is enough. So it is the least demanding of the different ways you can obtain a legal historical perspective. If you want to find a longue durée, you can also use secondary sources. You usually use secondary sources. It is almost impossible to ask for a company lawyer used to work with company law today to go back and read the medieval sources and from them conclude are they saying, what kind of company law did we have in 1274? Because reading medieval legislation is really an art in itself. So I would very much underline that if you try to find a longue durée, rely on secondary sources. The same when it comes to identifying general values or principles to be observed throughout history. Again, it is because it is an art in itself to study medieval legislation and early modern legislation. It would be wonderful if you did, and I have experienced several times that people in their thesis have taken the time to learn how to read medieval and early modern legislation. I would not advise you to do so unless you have an urge to do so, because it is time-consuming. If you write legal history to establish a direction of change, then you use both primary and secondary sources. You can use both, because then we're talking about immediate legal history. And as I said, in immediate legal history, you often use the same legal sources as legal historical sources as you use to determine what is law today. That's the kind of sources you're very well competent to work with. So no problem using primary sources then. And if you, of course, legal history is the purpose of your thesis, then you work with primarily primary sources. You can also work with secondary sources, but primarily primary sources. And now I'm going to end my speech because there's supposed to be time also for questions and reflection, but I'll just show you this one last slide, which is of great importance, and that is whose legal history. When we think, at least my colleagues often think about company law legal history, they have a tendency to think about Roman law as the beginning of company law, and well, it is not, by the way, but that's what most people think. So they start with Roman law. Roman law has become some kind of a universal law in the European legal history. and it is very relevant for company law, and writing about Roman law will always get you somewhere. Not that much. Well, there's also something for sustainability, but not as much as it is for company law. What is more natural, I would assume, is to write the history of the company law of your nation, whether that is the longue durée or the immediate legal history, because company law was nationalized approximately 1800. Before that, company law was, to a great extent, fairly transnational or international. While sustainability, though, has always been a part of the international, more transnational set of norms. So, but company law can very easily be tied to a nation's legal history. Both company law and legal history, if you write immediate legal sustainability, and company law, if you write immediate legal history, of course, linking it to a transnational entity like the EU is the most common thing to do. So then you write about the legal history of the EU, really, while you write also about the legal history of company law, sustainability. And the most important thing is maybe sometimes the comparison can add something. Of course, if you feel it's challenging to use a legal historical perspective, don't add comparison, because it adds another dimension of difficulty, and maybe you need the resources to concentrate on the company law, sustainability law that you're writing on. But comparison always brings out the best in the material. Comparing, for instance, national law, company laws, and the history of national company law and the EU company law combined would make a wonderful legal historical addition to your thesis, for instance. But I think I've overstepped my time, Jukka, but I really wanted to add something about comparison. So that's why I also wanted to include this slide. But that would then be my speech. And yeah,